Republic of the Philippines vs. JOCELYN ASUSANO KIKUCHI GR number 243646, June 22, 2022. Doctrine. Article 26, par. 2 of the Family Code provides that where a marriage between a Filipino citizen and a foreigner is validly celebrated and a divorce is thereafter validly obtained abroad by the alien spouse capacitating him or her to remarry, the Filipino spouse shall likewise have capacity to remarry under Philippine law. In Republic v. Manalo, 831 Phil 33, 75, 2018, citing Garcia v. Riccio, 418 Phil 723, 731, 2001, the Supreme Court held that before a foreign divorce decree can be recognized by the court, the party pleading it must first prove the fact of divorce and its conformity to the foreign law allowing it. As both of these purports to be official acts of a sovereign authority, the required proof are their official publications or copies attested by the officers having legal custody thereof, pursuant to Section 24, Rule 132 of the Rules of Court. Facts. Respondent JOCELYN Kikuchi, through her attorney-in-fact, Edwin Asusano, filed before the trial court a petition for judicial recognition of foreign divorce. She alleged that she was married to Fumio in 1993, and in 2007, they jointly filed for divorce before the City Hall of Sakado City, Saitama Prefecture. When the case was set for hearing, the OSG authorized the city prosecutor to appear on its behalf with only notices or orders, resolutions, and decisions served on it. OSG will bind the party represented. During the presentation of evidence, the following documents, among others, were presented. 1. The acceptance certificate issued by the mayor of Sakado City, Saitama Prefecture, Japan. 2. An authentication from the Vice Consul of Philippine Embassy in Tokyo, Japan. And 3. A photocopy of the Civil Code of Japan in English text. The Republic, through the OCP, did not object to the presentation and offer of such evidence and manifested that it will not be adducing controverting evidence. The RTC granted the petition, prompting the OSG to appeal the case to the CA. The appellate court affirmed the ruling of the RTC. Agreed, the OSG appealed, Rule 45, the case to the SC. The OSG raised the following arguments. 1. Kikuchi failed to comply with the requirements of authentication and proof of documents concerning the acceptance certificate, and the authentication by the Philippine Embassy in Tokyo, Japan. 3. That Edwin's testimony as to the fact of divorce should have been excluded for being hearsay. 4. And that the foreign law had not been proven. Issue. Whether or not the petition for judicial recognition of foreign divorce will prosper. Ruling. No, the case is remanded to the court of origin. JOCELYN failed to establish the law of Japan on divorce. For a petition for judicial recognition of foreign divorce to prosper, the party pleading it must prove the fact of divorce and the national law of the foreign spouse. In this case, in order to sufficiently establish the fact of divorce, the pieces of evidence presented by the respondent should be assessed. To this end, the following were duly established. 1. The acceptance certificate issued by Mayor of Sakado City, Saitama Prefecture is equivalent to foreign judgment of divorce. The only difference is that the acceptance certificate is issued by the mayor while the foreign judgment is issued by the court. 2. The authentication, issued by the Embassy of the Philippines in Tokyo, Japan, accompanying the acceptance certificate complies with the rules on authentication because it, authentication, certifies that the acceptance certificate was signed by the official of the Consular Service Division, Ministry of Foreign Affairs, Japan, that said official is authorized to sign the same, and that his signature is genuine. Ergo, these facts contained in the authentication sufficiently renders it admissible as evidence of the fact of divorce in compliance with Rule 132, Section 24 of the Rules of Court. 3. Edwin's testimony, although hearsay, is admissible for failure of the Republic to object to the offer of evidence. 4. JOCELYN was unable to establish the law of Japan on divorce because the translations by Ibn Horiaisha, Incorporated, the publisher of the document submitted by JOCELYN, are not advertised as a source of official translations of Japanese laws. Given that JOCELYN was able to prove the fact of divorce, but not the Japanese law on divorce, a remand of the case rather than its outright dismissal is proper. This is consistent with the policy of liberality that the court has adopted in cases involving the recognition of foreign decrees to Filipinos in mixed marriages.